Alex here with a legal nuts and bolts video on discretion. Judges have a certain amount of discretion depending on what they're making a decision on. If it's, let's use an example. Start off right with an example. For example, child support in Nevada at least. The person who is awarded child support is determined based on who has physical custody. So the court has to determine who has physical custody, and whoever does, that's the person that gets child support. If it's joint physical custody, then there's an offset between the two. But there is no discretion there. The judge has to award it. When it comes to a dollar amount, there's another set of statutes that discusses how much a parent gets based on how many children are being supported and based on a percentage of their income. Again, a statute with very specific language controls the court. Another area of the law that seems very similar is alimony. Well, with alimony, the court has a lot more discretion. There are statutes and mainly case law discussing when a parent is entitled to an alimony award, and it has to do with, like, if there was a stay-at-home parent, somebody who hasn't been working for a long time or isn't able to work, or like, for example, if one parent helped another one get through college, something like that. That parent is entitled to alimony, but there is no specific statute that says exactly how much that parent is supposed to get. That is an area where the court has discretion. I feel, after having gone through 8 years of representing myself, that discretion is the root of all evil. Not gender bias, discretion. I've noticed patterns too. So, for example, in areas where corporations are involved, real estate, issues like that have to do with mergers, licensing, anywhere that a lot of money is going to be, personal injury, medical malpractice, anywhere that large entities are conducting business, anywhere that tremendous amounts of money are in the hands of not attorneys, but the actual participants in the court system, that's a very clear distinction I need to make. These areas seem to have statutes that are much stricter. Statutes that carefully control what the court can do. And I can't imagine that that's a coincidence. In family law, so child custody, divorce, orders of protection like against domestic violence and stuff, the statutes are much looser. There's areas all over the place where the court has tremendous amounts of discretion. And it can't be a coincidence that this is where the judges are making mistakes all over the place, alienating the public. I feel like this is where the root of all the problems are coming from. The problem, well, one of the problems is that it's very difficult to challenge a judge's decision if that decision is in one of those windows where they have discretion. It's possible to do it, but it's not as easy. I should just go through my 4 appeals and talk about how I beat those. Let's see, appeal number 1. My ex's attorney got an attorney fee award issued against me as a sanction. What did I use? I used a specific statute that said that the court had to analyze 2 things that the court didn't analyze. So the court had no discretion there. The court just didn't follow the law. So I won that one. Award of costs for winning my appeal. There was a statute that said I was entitled to costs. Mandatory. Didn't say may, didn't say can be considered. The statute just said if Alex wins his appeal, he gets costs. The court denied my request. I appealed. I won again. But once again, the court didn't have any discretion. The third area, costs again. Same exact thing. I filed a writ petition, won, cited a law that said the award of costs was mandatory. Judge ignored the law, denied my request, filed an appeal, won. So that's 3 appeals right there where the court had no discretion. 4th one was a little bit awkward. It was a landlord that I sued. He represented himself. I opposed because under the law of the state of Nevada, you can't represent yourself if you are a business entity, which the landlord was trying to do. He was trying to represent his LLC, which you can't do in Nevada. Again, there's no discretion there. So if you look, I've won 4 different appeals, and all of those were areas where the court had no discretion. Could I have won an appeal where the court did have discretion? I'm not so sure. I know it's harder. I've looked at the case law on it. You have to show that the court abused its discretion. And from what I've seen, you have to show that the court made a decision that was arbitrary or capricious. I don't really fully know what that means. Those words are pretty vague in themselves. I'm sure if I did a tremendous amount of research on it, I could get it narrowed down a little bit. But that's just an example, hopefully, to my viewers that discretion is an area where the court can get away with some of its shenanigans. If there was going to be bias, that's where it'd be. If a judge hated you and wanted to get revenge on you, that's where it would be. The other thing that's not good about discretion is it creates uncertainty. And I think I connected this to one of the major problems that I addressed in my video, MGTOW and MRA. I'm pretty sure I did. The ultimate problem is, I know that the MGTOW and MRA movements make it about a gender war and gender inequality. But what they're looking for ultimately, I mean, a lot of people say, well, they want to just be on top again. Some people say they want to be treated equally. But I think deep down, further than that, is they want some certainty. And I think with joint physical custody statutes becoming the presumption in Nevada and hopefully across the rest of the country, I'm hoping that over time it'll become less of a gender issue, and both sides, men and women, will see that what they both want is a little bit of certainty. People don't like that the system has a tremendous amount of power over their lives, and there doesn't appear to be real meaningful limitations and boundaries on this insane amount of latitude that these judges have. I did mention in that video that what it came down to for me was that the judges cannot be trusted. You cannot give the judges more and more discretion on this misplaced notion that they're going to just do the right thing out of the goodness of their hearts. I don't think there is a bunch of judges out there that want to just ruin people's lives on purpose. But I think there's a lot of judges out there who don't really like their job that much, are bored at work just like any other person, are not paying attention, are not looking at the details, flat out don't care what happens. And some judges actually do care, but they have misplaced ideas in their head. They have understandings that to them seem like they make sense. For example, watch my video, end of filings is not end of abuse. That's one of the most common mistakes that these judges make. They think that if you keep coming back to court, something's wrong with you. What they don't realize is maybe the person who's coming back to court over and over again actually has legitimate issues and is trying to protect a child. It's not every single person. Some people who file 1 million papers are the abuser, but some people aren't. Well, there's judges out there who think that they have to put a stop to it. They don't understand that maybe the person who's coming to court over and over again is the person who's actually trying to protect the child. These judges are the ones that are going to abuse their discretion. They're going to use these areas where they have wide latitude to punish that parent, even though they're the one trying to protect the child. This is the problem, is the legislatures, what it seems to me, the legislatures of the 50 states seem to think that strict statutes will somehow get in the way of judges trying to protect children. But what really happens is judges who are giving too much leeway are making mistakes based on their own misconceived notions, just wrong-headed, magical fairy tale thinking about people who are just personality disordered with mental health issues, somehow coming to a reasonable agreement with the other parent. Just ignorance, not knowing how mental health disorders work, not understanding what parental alienation is. The judges just, there's so many ways for them to go wrong. From my 8 years of representing myself, what it came down to is controlling the court more seemed to be better. What the judges didn't need was more discretion. What they needed was more guidance. What they needed was the legislature to nail things down, to tighten their control on the judiciary. What I think the legislature really needs to do is listen to mental health experts like Dr. Steve Miller and Dr. Craig Childress and fashion statutes are based on what these experts are starting to discover when it comes to high conflict child custody, because then those statutes would become binding on the judges, and those judges would have the guidance they need to actually navigate high conflict child custody cases, which in my opinion very few of them really can get like a grasp on. I feel like things are not going to ever go in this way, because I don't think people understand this. I don't think people see discretion as the root of all evil. I think people see what they term to be bias and corruption, which I really don't see a whole lot of. I see some bias, yes, I see almost no corruption. What I see is a tremendous amount of incompetence. I see judges making mistakes because of all the reasons that I mentioned earlier in this video. Not because they're corrupt or they don't like you, but just because they just don't know what they're doing. And so I was able to obtain success a lot, in large part because there were certain areas of the law where I could control the court and unfortunately force them to do what they were supposed to do because they weren't going to do it otherwise. It would be really nice if people could sort of get, an understanding that this is the problem. That in the end, hopefully after the gender bias wars end, people hopefully notice that what they all really want is some certainty when it comes to the divorce and child custody process. People want to think if we end up divorced or in a child custody dispute, the judge is tightly watched and controlled as to what they can do. The judge has limits and boundaries as to how much they can impact my life. People want that. People want that little bit of, I guess you could call it confidence. Security is a better word. Ultimately, the idea that things are just completely up in the air and in the hands of a one-robed personality is a scary thought. In fact, most people are afraid of the court system because they think that's true no matter what, and because people don't understand the court system. The more people learn that there are many areas of the law where the judge is tightly controlled, the less people would be afraid because you could more reasonably predict what's going to happen. That's what it comes down to. As human beings, when it comes to their children, they want to be able to predict at least reasonably what the process is going to be like and what could happen. But right now people are terrified. People are learning about friends, associates, and family members losing homes, not seeing their children for years, flat out never seeing their children again. These things are not supposed to be, I don't want to say possible because in rare circumstances they are, but right now it seems like it's happening all over the place and it's scaring people, it's terrifying people. People don't like that their ex can just accuse them of something like domestic violence and then they go to court and regardless of all the proof they have, it doesn't matter because according to the law, their ex didn't have to prove that they did anything to them anyway. All they had to prove was that it might one day happen, possibly. That's what I talk about in my video, restraining orders. That the law specifically states that as long as the person requesting a protective order can show a potential of domestic violence, then they get a protective order. Nowhere in there does it define what that is. A text message of you saying something mean, somebody alleging you called them and said you were going to kill them, an angry letter after you found out you were cheated on. Nobody knows. There's nothing. The statutes don't say. So the discretion is wide open. So different judges can decide different things, and it just feels very unfair to people when they go to court and they get this one outcome, and their friend had the same situation, yet they get a completely different one, and their dad had the same situation, yet the laws were so different back then that there was no limitations on what the judges could do when it came to custody. And it's just these when it comes to the child support statutes, I feel like the courts are all going in the right direction. They imposed the formulas. They created statutes on what deviations could be applied, specific definitions of deviations. They established case law saying that judges must explain their reasoning. When it comes to other areas, like lately the award of attorney fees for equal, there's all these other areas where discretion is widening. And so it's really frustrating for me to see things like that happening. I don't know if anyone here has a story where they believe a judge abused their discretion, where they believe that their judge's incompetence or ignorance or bias bled through in a particular area because that was an area where the judge had discretion. Please post it in the comments below. I really think that this is the solution going forward for all families, for anyone who doesn't want to go through a system that could potentially just trigger a nuclear bomb in their life and just leave them not even understanding. I mean, like, this video could go on for 30 minutes if I compiled a list of things that happened to people. Some people had multiple businesses and lost all of them. Some people found themselves homeless. Some people found themselves living with their parents. It's just, It's just, you never know it's just the not knowing that scares people. And I think that's what fuels the MGTOW movement. They basically decided, since we don't know what could potentially happen to us, the only way we can avoid it is just by not getting married, not having kids, and not having a relationship. Even the domestic violence statutes specifically state that you have to abandon a relationship to apply for them. I'm not sure if there's anything in there about, I'm not sure how they define a relationship now, so that might not be that simple, but it's basically that's the reaction that's starting to happen. There's movements of people that are saying, since we don't know what's going to happen to us if we go through that machine, since we're unsure, we're just not even going to go, we're not even going to get involved with it. We're not going to do anything that could remotely put us through the machine because we just don't know what's going to happen to us. It's a very reasonable reaction, and it's a really sad one, and hopefully it gets to the point where enough people think we need to clamp down. We need to stop letting family judges have discretion all over the place to do whatever they want. We need to find all of the various different areas where they have discretion and narrow that window of discretion down as much as possible. More statutes means more guidance. By the way, in case anyone hasn't realized this, plain statutes, some people think lots and lots of laws are good for attorneys because more laws must be more money, but it's not true. More laws make things clear, at least not if they're not contradictory, if it's not just a hodgepodge rat's nest of statutes. If there's a purpose to each statute, if there's a necessary complexity there, not an unnecessary cluster, it makes it so that it's easier for people to understand what the outcome might be. It makes it more predictable. So attorneys it's less likely that people will need a lawyer because they'll be able to read it, or even attorneys will be able, when an attorney is reading it, will be able to say, this is probably what's going to happen. So it makes it less likely that things will go to trial. The more wiggle room is available, the more an attorney can take that and try and make an argument out of it, and try and force an issue to court, try to extract money in that sense. Attorneys, here's the other thing that's frustrating. For some reason, people seem to think that more discretion means the judge has a wider latitude to help the non-attorney. But that's not what I've seen happen. In practice, what happens is attorneys exploit discretion, areas where there is discretion, to get what they want. And because attorneys have a stronger relationship with the system and a better understanding of it, they're able to leverage windows of discretion in their favor. When I was representing myself against my ex's attorney, she took any possible window of discretion that she could possibly find, and she would twist it and go as far out of bounds as she could with it. I was able to control situations where the law was very strict and she could not lawyer her way through it. So it's just, number one, it's going to make it easier to represent yourself if there's clear guiding principles for the court to follow. Number two, it's going to make it cheaper because it's less likely that things are going to go to court and litigate when it's very clear what could possibly happen. And then number three, it makes things less scary because you don't have that feeling of, I don't know what's going to happen to me. The potential is so outrageously huge that I can't reasonably put a boundary on worst case versus best case scenario. It's just wide open. So it's just, I hope that I explained, this is one of the toughest topics that I have ever covered because I wanted to really get the point across, and I wanted to cover as many angles as I possibly could when it came to discretion because there is a lot of different angles and a lot of people say different things. I'm a firm believer that going forward, it's going to be one of those things where at least hopefully the gender wars end and men and women are on the same side, and hopefully they all come to the same, most of the people come to the same conclusion that I just did, and there's a more conscious effort by the public to demand not just random family law reform, which seems to be the popular thing lately, just people asking for family law reform just randomly without any specifics. I mean, there was some movements concerning abducting children, and then there were some other movements concerning joint physical custody, but I hope people get more specific and say, we want some certainty. We want some control. We don't want the judges to have all this leeway. We want to have a set of rules set up that they have to follow so that we can be comfortable and secure in knowing what might possibly happen to us if we end up going through that system. I don't think the MGTOW and MRA movements are going to go away if there is gender equality on paper, but and it's not gonna. I don't want to say that it's necessarily going to be gender bias in the courtroom, but they will perceive it that way. When the areas that the judge is making rulings on have wide areas of discretion, even though the judge may not be actually acting in a biased way, in their own head gender biased way, I think those movements will continue to see it as bias, regardless of what the judge's intentions are. So, I mean, I don't see, and I'm not sure now, but it seems that a lot of mothers are starting to come forward now that the joint physical statutes are starting to take hold, and there's a lot of parents with joint physical custody that are abusive, fathers that are abusive or have personality disorders. It appears that even women and mothers are coming forward, and they're starting to notice issues too now, though their movement is not quite as cohesive because it just, the whole issue with gender bias and going into custody awards has just been happening for much longer, for many more decades. It's allowed the MRA and MGTOW movements to cement for years instead of this joint physical custody phenomenon, which is relatively new, and there doesn't seem to be a strong mothers movement when it comes to protecting children. I certainly have not heard of any mothers movements asking for a shift back to just getting automatic custody like they used to. It seems like they're all just dealing with educating the courts on narcissism and other mental health issues. But anyway, it's all going to come down to, in my opinion, less discretion. Less discretion is better. I'm not sure that attorneys and legislators are going to want to hear that. In fact, if it's going to hit their pocketbook, they probably are really not going to want to hear that. But anyway, with that being said, what can we do? Go ahead and post anything you want in the comments below. I think I've mentioned that about 3 times now. I'm looking forward to getting some feedback on this topic. Discretion scares me. I've been through the system, represented myself for 8 years, and that's just the one thing that you never know what a judge is going to do. And if a judge ever didn't like me and wanted to punish me, that's how they do it. So anyway, with that, I will go ahead and end this video, and I'll see you guys next time.